Lieutenant Carey, if you can hear me, I think the only case you had was Bailey. And if that's it, you're excused.
Thank you.
Thank you. Have a good one.
You too.
So just want to confirm, Mr. Sanchez just has the one charge, correct?
That's correct, Judge.
All right, so now calling the matter of State of Georgia versus Alan Sanchez, 2024 WA01185, aggravated stalking. Representing the state is Attorney Freeman. Representing the defendant is Attorney Rogers. Your witness, Attorney Freeman.
Thank you, Your Honor. Officer Mimic, would you raise your right hand, please? Do you swear and affirm that the testimony about to provide in the matter of State of Georgia versus Alan Sanchez will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
You can lower your hand. Please tell us your name and how you're employed.
My name is Alan Memick. I'm lieutenant with Riverdale Police Department.
Lieutenant, how long have you worked with the Riverdale Police Department?
13 years.
And sir, were you working with the Riverdale Police Department on January 5th of 2024?
I was.
On that particular day, did you respond to a domestic disturbance call at 8201 Mountain Pass in Riverdale, Georgia?
I did.
When you got to that location, who did you speak with?
When I arrived at the location, I saw Mr. Sanchez standing at the front door, kind of leaning on the front door and knocking on the door. I made contact with him and asked him to step down and talk to me. At first, he refused, but then he came down and spoke with me.
When you initially got the call, were you given any other information regarding what was going on?
Yes, the 911 dispatcher advised me that the complainant stated that her ex-boyfriend was at her location, banging on the door, refusing to leave, and that she has an active temporary restraining order against him.
Lieutenant, were you able to confirm whether or not the victim in this case had a restraining order against Mr. Sanchez?
I did confirm it. I detained Mr. Sanchez and ran his oil land through GCIC, and he did come with active TPO.
Just so we're clear, when you arrived there, you witnessed Mr. Sanchez at the front door of this residence?
Absolutely. He was at the front door and he turned around, saw me. Even when he saw me, he didn't even bother to come downstairs. He just kept going, knocking on the door.
Were you able to speak with the homeowner at this time?
I spoke with the complainant, her ex-girlfriend, and she's there with her. Apparently they have a child together, and she advised that she didn't call him in and that he just showed up, and that they had previous domestic issues, and that she had the restraining order against him, and that she was afraid for her safety.
Is this Miss Lakeisha Swain?
That's correct.
How were you able to get Mr. Sanchez to leave the front door?
I had to order him to come down the steps.
Was he compliant? Sir, was he compliant with you?
When I asked him to come downstairs, he didn't. When I ordered him and I ordered him to come down, and then he did.
Did Mr. Sanchez make any statements to you about why he was there?
He made a statement that he was there to see his son.
Did Mr. Sanchez say anything regarding the restraining order?
If I'm not mistaken, I believe he said that he was aware of it, but he had to come and see his son. That he knew about the restraining order, but he wanted to come and see his son, and he wants to see his son.
Did this incident happen in Clayton County?
Yes.
The 8201 Mountain Pass Drive, is that where Ms. Sway resides?
That is correct.
Yeah, thank you. I have no further questions.
All right, cross-examination.
Lieutenant, just a couple of questions. I know you mentioned having a brief conversation or a conversation with Mr. Sanchez. First question, is that conversation captured on your body cam?
Yes.
And then at what point are you all having that? Well, let me ask, when you're having the conversation, has Mr. Sanchez already been arrested at that point?
The beginning of the conversation, no. I couldn't recall if he was detained. I believe he was detained at that point. Yes.
When you say, well, let me ask you about that distinction that you make. You say he was detained at that point, but well, let me ask you, I guess, are you making a distinction between him being detained and arrested at that
Well,
point?
here's the reason he was detained. Okay, when I got out of the vehicle, I asked him to come down and speak with me. He refused. The way he was leaning to the door, he had hand in a pocket and refusing to turn around. At that point, I took precautions because wasn't sure if he was armed or anything. And when he came downstairs, when my backup arrived, we detained him based on his actions and body movements.
Okay. And so at the point that you just spoke about when you detained him, have him come down and detain him, I guess first question, is he in handcuffs at that point?
Not right away. No, not right away.
What about when he comes down? I guess he comes down the stairs to where you are.
When he comes down the stairs where we at, I asked him to sit down. He sat down, and I'm not sure at what point I asked him why was he here or not. But as soon as my backup arrived, we went and detained him.
And at that point, had you already gotten the information as far as verifying the TPO at that point?
At that point, I didn't verify the TPO. I just went on what the dispatcher said. And once he got detained and placed in detained, I ran a oil in through my GCIC, and then I verified that there was a temporary restraining order. And then he was arrested based on that temporary restraining order.
No further questions at the moment.
Can you redirect?
No, Your Honor, the state rest.
All right, closing argument.
State waives opening.
Attorney Rogers.
Thank you. Yeah, I guess at this point, I would argue that I would ask that all the charges be dismissed for lack of probable cause. The reason I would ask that is that so far what we have testified to, if I understand it, is a single incident. And there's case law, give me a second, I'm gonna get it right in front of me, that says that a single incident, a single violation of a protective order by itself does not amount to aggravated stalking. This is State v. Burke, 287 GA 377. And the court there says that, and I'm quoting directly, quote, based on the plain terms of the stalking statutes, a single violation of a protective order by itself does not amount to aggravated stalking. It goes on to say that the harassing and intimidating conduct must be established by, among other things, a pattern of harassing and intimidating behavior. And that a single violation of a protective order alone does not establish that pattern. Additionally, the other thing I would point out is that when the purpose has to be for harassing and intimidating, based on what the conversation was between the officer and Mr. Sanchez, or between the lieutenant and Mr. Sanchez, his purpose there for being there was to see his son. That's not, in and of itself, that's not a harassment, intimidating purpose. The I would concede that what's been alleged is a violation of a TPO. So I'm not quite arguing that there's no basis for any charge, but as far as the aggravated stalking, I would say that both the purpose has not been satisfied, and additionally the pattern has not been satisfied. Also, just another case, Stevenson v. State, in interpreting Burke, or at least decided after Burke, the court says that a course of conduct refers to a series of successive actions equivalent to a pattern of behavior. So based on those two cases, I would say that at this point there's been no pattern established. And additionally, just to go back to Burke one more time, it also says in Burke, and again I'm quote reading directly, nor does the mere existence of a protective order obviate the state's need to establish every element of the offense of aggravated stalking, where one of the required elements that the state must prove is that a pattern of behavior exists. So for the lack of pattern and the lack of purpose, Sean, I would be asking that the charge be reduced to a violation of a TPO as opposed to an aggravated stalking.
All right. Attorney Freeman?
Judge, you were asking that you bind this one charge over, to Superior Court. You know, we heard a testimony from Lieutenant Mimic about the defendant's conduct with his behavior. In that same case that Attorney Rogers talks about, it indicates that the court, in considering the pattern of harassing and intimidating behavior, the court can look at a number of factors, including the prior history and the defendant's conduct, as well as his overtly confrontational acts. I mean, Judge, when Lieutenant Mimic arrived there, he saw the defendant banging on the victim's door. He turned around when he saw the police there, then he turned back and continued to bang on the door. When the officer asked him about, being there, he acknowledged he was aware of the temporary restraining order, and it didn't matter to him. He just stated that he wanted to see his son. He knew he wasn't supposed to be there. He was banging on his ex-girlfriend's door. And Judge, we believe that that should be sufficient for probable cause for this aggravated stalking charge. And we're asking you to bind it over to Superior Court.
Mm-hmm. So So I believe that based on the fact that this should be a misdemeanor and not a felony, so I would downgrade it to a misdemeanor. That would be. This was 16,591, should be 90. Yes, 16,590. All right, so to order the court, I'm gonna downgrade this from aggravated stalking to stalking.
And just Lieutenant Mimic be excused.
Yes, thank you.
Thank you, Lieutenant. Have a good
All
one.
right. Thank you. Have a good day.
Thank you.
All right, who are we doing next?
And I think the attorneys wanted to go back to the breakout room with the jail.
Yes.
Deputy, if you would join cameras and automatically join.
Judge, what's